Hello, and welcome to this episode of the Maryland Risk Management Education Podcast. My name is Paul Goeringer, and I'm the Extension Legal Specialist here in the Department of Ag and Resource Economics. Thank you for listening to this episode, and today we're going to talk a little bit about something that many of you will be thinking about in the coming months, which is whether or not to terminate or give notice to start terminating some of the leases that you're involved in, whether you're the landlord or the tenant. And the main reason I want to talk about this issue today is to talk about some of the things that can happen if you're the tenant and you decide not to vacate after you've been told to leave the premises and become a holdover tenant. In many cases, depending on the state you're in, depending on when notice has to be given, Maryland, it's 6 months. Typically 6 months before the end of the lease, you need to give that notice. So what happens if the tenant decides not to listen to that notice to terminate the lease and decides to stay on the property? So we'll talk about a case out of Illinois that kind of highlights what problems can erupt when this happens, especially in a multiple co-owner situation to where we have multiple landlords we're dealing with, and one landlord tells us to stay and the other one tells us to go. What happens in those situations? So let's talk a little bit about the facts. We have Doug. He leased a piece of farmland co-owned by both his Aunt Ruth and his dad, Robert, under an oral farmland lease. First problem in this case, you will notice I will come back to later, is the fact that it was an oral farmland lease. It probably should have been in writing. Ruth owned an undivided 75% interest in the farmland, and Robert held an undivided 25% interest in the farmland. In 2016, Doug failed to pay a portion of the rent for the 2016 crop year, and Ruth sent him a written notice she was terminating the lease. In the written notice, Ruth gave Doug a date in February 2017 to turn over possession of the property. Robert did not agree that the lease should be terminated and told Doug to continue farming without Ruth's consent. What father's going to tell his son to get off the property, I add parenthetically. Doug continued to farm the property in 2017 and did not pay any rent that year or make a final payment for the 2016 year. Pay attention. That's probably going to be a problem later. Ruth sued Doug to terminate the lease in late 2017, and at trial, Ruth was awarded damages of $62,726, the portion of the 2016 rent not paid, and all of the 2017 rent. Doug appealed that decision. So we get to the Illinois Court of Appeals, and the Illinois Court of Appeals turns and looks at what the Illinois Code says when it comes to holdover damages. And with holdover damages, the statute provides willful holdover basically means if any tenant or person who is in possession comes into possession of lands or tenements by or from or under the collusion with the tenant, willful holds over any lands, tenements after the expiration of his or her term or terms and or demands made in writing for the possession thereof by his or her landlord and or the person to whom the remainder or revisions of such lands belongs. The person so holding over shall, for the time the landlord or rightful owner is kept out of possession, pay the person so kept out of possession or his or her legal representative at a rate double the yearly value of the property, so detained to be recovered by civil action. So that's the statute provision there. It'll be linked in the blog post that I have up covering this. But according to the Court of Appeals, the willful holdover damage provision allows for double the yearly value of rented when a tenant willfully holds over. To the court, the tenant willfully held over after the tenant received written notification. You already had it, you stayed on, you knew it, you did it deliberately. That's all it took in Illinois. According to previous decisions of the Illinois Supreme Court, a holdover is not willful when the tenant continues to have a reasonable belief that the tenant could stay on the property. Here, Doug didn't have a reasonable belief. One landlord told him to get off the property. The majority landowner, the person with the smallest interest in the property, told him to stay on. That was not enough to create some sort of reasonable belief to the court. The other issue the Court of Appeals had to handle was about the case where co-owners did not agree on terminating the lease. Prior decisions in Illinois allowed just one co-owner to provide notice to terminate the lease without the approval of the other co-owner. owners. The Court of Appeals saw no reason to disagree with this, so they uphold this decision. So upon reviewing the facts, Ruth gave Doug written notice to terminate. Doug ignored this notice and continued to farm the property without paying rent. Based on these facts, the Court of Appeals upheld the lower court's decision. There's not much legal analysis in this opinion. It's pretty cut and dry when you read it. So why should you care about this? Well, similar to Illinois, a lot of states, Maryland included, have some kind of holdover statute allowing landlords to collect damages for the holdowner. Now, Maryland's, and it's in the post, you can look at it and look at the code citation. Maryland's law does not provide similar double damages for a willful holdover. Maryland's holdover damage is just typically limited to the amount of rent owed during the period and any rent that's left unpaid. The other reason to care is who has to provide notice to terminate the farmland with multiple co-owners. In this case, prior decision said it could just be one of the co-owners. What if there had been a written lease in this case? What if Doug and his aunt and his dad had come up with a written lease that specifically said who could give notice? That may change the outcome in this case. Ruth may have not been able to give notice in that case. These are things you kind of need to think about as you're developing these leases, because there's a lot of areas where leases may not always, what the courts allow and what's written in a lease may be different, but what we do in the lease may be something that's better fitting for us, and we're able to get around, multiple co-owners, one just being able to give us notice, and we will have one who makes the decisions for all the co-owners who's making that decision. Along with this, I'll put a link up to the ag leasing page that's on the University of Maryland Extension's websites to help you with some other decisions that may come up. Thank you again for listening to this podcast today. If you have any questions or ideas for future episodes, please let me know. My email is lgoering@umd.edu, or you can tweet me at aglawpaul. I'm also on Instagram, and you can message me there, same aglawpaul. Please, if you have ideas, let me know. But again, thank you for listening, and enjoy the rest of your day.